3, 2, 1, start. In the writ application, it had been averred, inter alia, that the petitioner joined the West Bengal State Electricity Board on 1st February, 1974 as an unskilled worker linesman, and that he was promoted to the post of HG senior linesman with effect from 1st July, 2001. Stop. Subsequent thereto, on 11 June, 2003, the petitioner, in the usual course of discharging his duties, accompanied by his superior officer, Sri Utpal Kumar Biswas, station superintendent of Birpara Group Electric Supply, went to a medical shop, namely Messrs. Gupta Medical Hall, situated at Birpara Market near the bus stand, for inspection of the commercial meter bearing number BRP/S/37 installed thereat in the name of late Hardwan Shah for apply of electricity to the said medical shop, presently run by Sri Gautam Prasan Shah, the eldest son of late Hardwan Shah, and upon inspection, it transpired that the said meter was defective, and the station superintendent, who accompanied the petitioner, informed the medical shop owner that the said meter would have to be replaced, which was objected to by the said shop owner. Stop. The petitioner was directed by the said station superintendent, Sri Utpal Kumar Biswas, to disconnect electricity supply to the said meter till the meter is replaced, and acting on the instruction of the said station superintendent, the said meter was disconnected by the petitioner. Stop. On the same date, in the afternoon at about 3:30 p.m., the petitioner was directed by his superior officer, namely, Sri Utpal Kumar Biswas, to replace the old defective meter of Messrs. Gupta Medical Hall, and pursuant thereto, the petitioner replaced the defective electric meter by a new electric meter bearing number BRP/S/37 and restored electric supply to the said premises of the medical hall, and deposited the old defective meter in the office. Stop. Surprisingly, thereafter, an inquiry was commenced against him on an allegation of taking bribe, and by an order number 133 dated 4th September, 2003, the petitioner was placed under suspension. Stop. Subsequent thereto, the petitioner was issued a charge sheet dated 1st January, 2004, and upon perusal of the same, the petitioner, by a representation dated 1st March, 2004, prayed for supply of the copies of the documents mentioned in the said representation, and the same was replied to the concerned authority by a memorandum dated 24th March, 2004, and the petitioner thereafter filed a reply to the charge sheet on 29th March, 2004. Stop. The inquiry commenced, and the petitioner participated in the same. Stop. In connection with the said inquiry, the petitioner submitted a written argument on 21st March, 2005, and the inquiry report was ultimately communicated to the petitioner, filed memorandum dated 23rd February, 2005. Stop. The petitioner replied to the said inquiry report. Stop. Subsequent thereto, the second so-called notice was issued to the petitioner, filed vide memorandum dated 28 September, 2005, proposing, inter alia, a punishment towards reduction of 4 increments from the present pay with cumulative effect and upon consideration of the petitioner's reply to the said second so-called notice, the disciplinary authority issued a memorandum dated 22nd April, 2006, imposing a lesser punishment upon the petitioner, which runs as follows: : para Roman 1, reduction of 3 annual increments with cumulative effect, that is, this deprivation shall continue till he is in the service of the board. Stop. Roman 2, he will examine his next increment on completion of 1 year's satisfactory service from the date of effect of order. Stop. Roman 3, the period of suspension in respect of Sri Roy is hereby confirmed. Stop. He will not get anything beyond the subsistence allowances payable to him during the suspension period. Stop. Next para. Aggrieved by the said order of the disciplinary authority, the petitioner preferred a statutory appeal on 9th June, 2006, and the same was disposed of by an order dated 14th September, 2006. Stop para. Mr. Mojumdar, learned advocate appearing for the petitioner, drew the attention of this court to page 22 of the said inquiry report, wherein it had been internally observed as follows: :para within double quote, from the prosecution and defense evidence and the argument, one thing is clear, within bracket 1, the line was cut which was irregular, within bracket 2, the replacement of the meter was not forthwith, within bracket 3, Sri Utpal Biswas did not take any action or call for written explanation from Sri Shankar Roy indicating his grievance, within bracket 4, both the charged employee tried to shift the burden on the other, within bracket 5, the prosecution witnesses are all local people and belong to two major political parties, indicating thereby that it is not an offshoot of any political rivalry. Decode. Stop. Next para. Mr. Mojumdar submits that the said findings arrived at by the inquiring authority do not stand fortified through appropriate reasons, and that the findings are absolutely perverse, and that the allegation of taking bribe had not been proved beyond doubt, and that the said allegation of taking bribe was made with a malafide motive to implicate the petitioner, though the petitioner was not at all present at Mrs. Gupta Medical Hall on 16 June, 2003, and that the evidence given by the brother of the complainant and the neighbor of the complainant would reveal that there were no witnesses to the alleged monetary transaction. Stop para. Mr. Mojumdar further submits that the charge pertaining to the petitioner's leave application dated 18th July, 2003, supported by a medical certificate dated 16th July, 2003, and the observation to the effect that the said medical certificate is totally false and fabricated, does not stand supported through the deposition of the prosecution witnesses. Stop para. Mr. Mojumdar further submits that the disciplinary authority had illegally taken into consideration the past service of the petitioner, inasmuch as there was neither any charge nor any imputation pertaining to such past service record of the petitioner. Stop para. Assailing the order of the appellate authority, Mr. Mojumdar submits that the said authority had neglected to consider the evidence adduced by the different witnesses in the proper perspective, and that it erred in holding that the matter of acceptance of bribe by the petitioner from PW3 had been established from the deposition of PW1, PW4, PW5, PW6, PW7, PW8, PW9, PW10, PW11 and PW14. Stop para. Mr. Mojumdar further submits that the appellate authority did not take into consideration the contents of the appeal petition prior to disposal of the appeal, and such infirmity maligns the said order of the appellate authority. Stop para. Mr. Bera, learned advocate appearing for the respondents, submits that it is a well-settled proposition of law that the power of the writ court to interfere with the disciplinary action is limited, and that the writ court does not, in exercise of its power of judicial review, reapprise the evidence, and that the writ court ordinarily does not sit in appeal over orders of disciplinary authority and the appellate authority. Stop. Mr. Bera further submits that the findings in disciplinary proceedings also cannot be interfered in exercise of the power of judicial review only because two views are possible and the writ court prefers the other view. Stop. According to him, an order of punishment is not interfered with, unless it is shockingly disproportionate to the gravity of the misconduct. Stop. Mr. Bera submits that the most important witness of the prosecution was Gautam Kumar Bagchi, who has been examined as PW1, and the said Mr. Bagchi is an officer of WBSC DCL, and on receipt of the complaint he went to the local and inquired into the matter and collected evidence from the local people and also obtained a statement from the petitioner. Stop.